Yes, Your Lordship. Your Lordship, I beg to mention item number 5, Your Lordship. Your Lordship, the arguing counsel, Mr. Pubin, is out of station, Your Lordship. I can pre-order for 1 week's time, Your Lordship.
Was this matter referred for mediation?
Lordship, no. It was not, Your Lordship.
Okay.
It was not, Your Lordship.
Any scope for?
Lordship, I don't think, because they have challenged the selection process of the private respondent, Your Lordship.
Oh, private respondent.
So I don't, Lordship, I do not see any.
But if I'm not, I may be wrong also. I think there are vacancies are there.
No, Your Lordship, no.
Not
Lordship.
okay.
Certain posts, advertisement have been called and they were filled up, Your Lordship. They'll come after 2 weeks, then, Your Lordship.
2 weeks, Your Lordship.
On premier by this letter counsel with petitioner seeking accommodation. Receive not be objected to by Mr. Indishwara. Matters adjourned. List the matter after 2 weeks.
Much
Apply,
obliged,
Your
Your
Lordship.
Lordship.
Supplementary list, item number 1.
Morning.
I have not even passed the order in your last case. Now you've come with another.
So that's the sequence of listing. I can't help it. It after every.
Same.
No, Lordship. This is a different matter. This is an NDPS matter. I've come on merits. I must be honest and say that this is the second time I'm knocking on the door of the Honorable High Court. I had come around 2 months back, Your Lordship, wherein I had made a single prayer. I had seek bail on account of delay. Only on account of delay. I have annexed the order as well, and Your Honor was inclined to reject the bail application on that ground. Only on delay I had.
Okay. How long?
This time what happened, Your Lordship, after the passing of that order, we have examined 2 more material witnesses, independent witnesses, and well, the depositions were such that which have actually given me a cause to prefer this bail application on merits. Hence this bail application, Your Lordship. If I may start, Your Lordship.
How many witnesses are there altogether?
Lordship.
How many witnesses are there?
A total of 11 witnesses.
11.
We have examined 3, but Caesar witnesses have been examined.
Only Caesar.
No, first was the complainant, and the other 2 and 3 were Caesar witnesses. Main witnesses, Your Lordship. Caesar witnesses are main witnesses, no doubt about it. You confirm if it's 11. Lordship, first thing which I would like to bring your Honor's attention to is the fact that the accused in this instant case, he is the applicant himself. He was arrested on the 1st of July 2023. Now he's been in custody for more than 2 years, almost 2 years and 2 months. He'll be completing 2 years and 2 months in custody on the 1st of September 2023. Lordship, before actually going into the depositions, which I'm strenuously stressing on, let us read the FIR which is annexed at page 47 of the petition.
Yes.
I'll start reading, Your Lordship. The FIR is dated 1st of July 2023. I'll start reading. With reference to the subject cited above, I am to inform you that on the 30th of June 2023 at around 8 a.m. received a credible information from a reliable source that 3 persons, namely Ronald Dong, he is the applicant, namely Ronald, Daniel and Naba Singh, were assembling at one farmhouse of Shri Ronald Kindia at Lumkini village, Umran, Ribhoi district to transact for a big consignment of drugs. On receiving the information, a Naka checking was set up at Umsning Junction bypass on NH06. Along with available staff of Umsning PS at the Naka, one black Alto bearing number ML05K0314 was intercepted at the Naka with 2 occupants inside. Upon questioning them, they stated the names as Ronald Kindia and Daniel CM, alias Sean of Shillong. They were unwilling to reveal the location of the drugs, following which they were detained for further questioning. During interrogation, they stated that the 3rd person was moving towards Guwahati, after which another Naka was set up near Barnihad outpost, and he was detained later that night at the Naka. On further interrogation with each separately, each of them confirmed that the drug consignment location was somewhere inside Ronald's uncle's farmhouse at Lumkini. However, since it was late and it was already 1 a.m., the accused persons along with the vehicle were detained. The matter was intimated to the SP. Following this, on the 1st of July 2023, K9 dog squad was requisitioned from CID Shillong, and after receiving authorization from Shri Ishan Gupta, Assistant SP, Ribhoi District, for conducting search at the premises and in the presence of independent witnesses, search was conducted at the aforementioned house. The sniffer dogs from K9 unit identified an iron box suspected to contain contraband. On opening it, 70 soap boxes containing orange powder suspected to be contraband were recovered. Let us stop there. Now, if we read the FIR, what comes to notice is the house was searched only on the 1st. At least this is what they're averring to us. At least that is what they're stressing upon, that they searched the house only on the 1st of July 2023, and that the sniffer dogs led to the recovery of an iron box from which 70 soap boxes were recovered, and that the powder contained in them were orange. So these three significant aspects, Your Lordship, that the house search was conducted on the 1st of July 2023. Second, that 70 soap boxes were recovered from a tin box, and third, that orange powder was recovered. Now, have these actually been stated by the independent witnesses as well when they were examined? No. Now, when we read the deposition of the independent witnesses, they speak about the house search also being conducted on the 30th of June 2023 as well. Let us go to the depositions now, Your Lordship. Please keep these three things in mind, Your Lordship, that the police is basically stating that they searched the house only on the 1st of July.
So the recovery was on 1st of July.
No, that's what they're saying, yes. And they're also stating that they searched the house only on the 1st of July.
Yes.
That is true. And they're also stating that they recovered 70 soap boxes from inside an iron box, and that the powder recovered was orange. Now, all these three aspects have been demolished by the Caesar witnesses. They've stated that the house was also searched on the 30th of June. Let us go to the relevant paragraphs of the cross-examination.
Commercial quantity.
Commercial quantity. But again, the Honour will make a reference, and I must also inform the court that the rigors of 37 would apply. But would it still apply after examining the material witnesses and after the materials which have come on record? No. The rigors would get diluted. I would satisfy the court on that accord. But firstly, let us go into the depositions of the witnesses, Your Lordship, if I may. So the relevant portions, Your Lordship, of the depositions, I've annexed the depositions, but the relevant portions I've paraphrased in the petition itself. I'll take you to paragraph 12. So, paragraph 12 of the petition. Kitna witnesses? Lordship, I stand corrected. There are 10 witnesses, not 11. I had stated 11.
It doesn't matter.
So we'll go to paragraph 12.
Yes.
So depositions have been attached to the petition, but I've quoted relevant paragraphs in the petition. So I'll start reading for para 12, Your Lordship. That both the Caesar witnesses have categorically stated in the in-chief itself, Your Lordship, and also in the cross-examination, that the police conducted the search of the house and the compound on the night of 30th of June 2023, and that nothing was found during that search then. And also that after the departure from the residence of Bak India, police officials stayed back in the residence of Bak India. Bak India implying the PO, residence of Bak India. PW2 categorically stated as in-chief in the following paragraphs. This in-chief, Your Lordship, paragraph 3 of the in-chief. On the 30th of June 2023 at around 8 p.m., while I was at home, the police came to my house and asked me to accompany them to the house of one Bak India located at Lumkini. Para 4 of the in-chief. I accompanied the police, and the members of the village Dorbar also went along with the police. On reaching the house of Bak India, the police started conducting search of the suspected contraband in the entire house, but did not find any contraband. We returned home. 3 policemen remained at the PO overnight. I'll continue reading. PW3 as well stated in his in-chief in the following paragraphs. Para 2 of the in-chief. On the 30th of June 2023 at around 9 p.m., while I was at home, I received a phone call from the village headman who informed me to immediately come to his house. From his house, I, along with the headman, went to the house of one Bak India, which is located within the village Lumkini. On reaching the house of Bak India, we saw that the police were conducting the search of the house of Bak India as well as the compound. They had already started the search before their arrival. On the 30th, I remained in the house of Bak India for about 2.5 hours, but since nothing was recovered by the police during the checking, I could not wait and I went back home. And during his cross-examination, he admitted, Your Lordship, para 5 of the cross-examination, it is a fact that some police personnel stayed back and spent the night in the residence of Bak India after the search of the residence on 30th of June 2023. So the house was also searched on the 30th of June 2023 where, and on that particular day or night, no recovery was made. Further, Your Lordship, we must continue reading. Actually, fine. The witnesses also admitted, Your Lordship, that even on the 1st of July 2023, nothing was recovered from the residence or the PU and from in and around the compound of the residence as well, Your Lordship. Let us go to page 8. Page 8, I'll start reading. PW2.
Yes.
PW2 categorically stated in his in chief in the following paragraphs. On the following day, at around 8 a.m., as instructed by the police, I, along with the members of the village, went back to the PU. On reaching the PU, we sat there for a while, and at around 9 a.m., we, along with the police, again started searching the place in and around the compound. The police found one big tin box from outside of the compound of Bak India, which was hidden in the bushes. PW2 also further stated in his cross-examination, upon being instructed by the police, I reached the house at around 8:30 a.m. on the 1st of July 2023. The search of the house on 1st July 2023 started at around 9 a.m. It is a fact that even on 1/7/2023, nothing was recovered from the house or from the premises of the house. On 1/7/23, I remained in the house till around 7 p.m. approximately. The search of the house on 1/7/2023 was completed by 1 p.m. and the other formalities of documentation were completed around 3 p.m. It is a fact that nothing was recovered from the premises of the house as well. Now, PW3, the other independent witnesses, he states in his in chief, on the following day, that is 1st of July 2023, again the headman of Lumkini village came to my workplace and asked me to accompany him to the house of Bak India. Immediately at around 8 a.m., I, along with the headman and some co-villagers, proceeded to the house of Bak India. At around 8:30 to 8:45 a.m., we arrived at the house of Bak India, and at that time, some police personnel were still conducting search inside and outside the house. Lordship, this may also be taken note of that the search had already commenced before the arrival of the independent witnesses. Para 7 of the cross. After some time, I saw the police recover one big tinted box from outside the compound of the house of Bak India and from inside the jungle area. PW3 further stated in his cross-examination, on 1st of July 2023, upon being called by the Ranbashnong, I arrived at the residence of Bak India at around 8 a.m. The timings, why am I referring to so much, I'll also get to that particular point. Next, Your Lordship, page 10. When I arrived at the residence of Bak India on 1/7/2023, I saw the police had already started the search. On 1/7/2023, I left at around 12 p.m. and after all the formalities were completed and after signing all the documents, the police did not call me after that. It is a fact that on 1/7/2023 as well, nothing was recovered from the residence of the compound of Bak India. That's the PO. It is a fact that nothing was recovered from the surroundings of the residence of Bak India as well. It is a fact that the tin box which I spoke of in my in-chief was brought by the police themselves from outside the residence and compound of Bak India. It is a fact that I did not see from where the police recovered the tin box. Lordship, when I referred to the affair, my basic intention was to bring to your honor's notice that the police have been silent about searching the house on the 30th of June 2023. The witnesses themselves in the in-chief have stated that the house was searched first on the 3rd of June 2023 and thereafter on the 1st of July 2023. On the 30th, how did they search and why did police officials remain in the house on the 30th of June 2023 and why were they called the next morning? All these facts, Your Lordship, have caused a serious end in the story of the prosecution. Let us also further read. Lordship, I'll read paragraph 14 if it's all right. It's a little important. That now if the papers relating to the search of the house, like authorization for house search, Panchnama, etc. are perused, one would find that the police has given a completely different narration of having had searched the house only on the 1st of July 2023 and that too after 2:30 p.m. as the authorization for the house search was issued at 2:30 p.m. while both the witnesses have clearly stated that the search of the residence, compound and premises started in the morning of 1/7/2023 at about 9:30 a.m. and that the search was over well before 2:30 p.m. That is the time of issuance of the authorization. PW2 stated that the search was over by 1 p.m. and PW3 also specifically stated that he had left the residence or the PO at around 12 p.m. Lordship, let us refer or go to the authorization certificate and the Panchnama, which are at pages 76 Lordship. Page 76, are we at page 76?
Yes.
So this is the authorization certificate issued by the police on the 1st of July 2023 for the house search of the PO. Let us read it, Your Lordship. I, Shri Ishan Gupta, Assistant Superintendent of Police, do hereby today on the 1st of July 2023 at about 2:30 p.m. at the farmhouse of Shri Ramul Kindia, authorize such and such officer of Umsning PS to conduct the search over the farmhouse and premise of Ramul Kindia. So the authorization for the search of the farmhouse was given at 2:30 p.m. Apparent from this, Your Lordship, and it's also apparent from a perusal of the punch number, which is at page 77. Let me just read the first paragraph. Today, the 1st of July, page 77, Your Lordship. Are we there? Right. So punch number, the first entry. Today, the 1st July 2023, at about 2:30 p.m., SIK Nongsiege of Umsning Police Station was authorized. At 2:30 p.m., was authorized by Ishan Gupta, IPS Reboy, to conduct search of the premise of the farmhouse of Ronald Lingdo's. Actually, it's Kindia, not Lingdo, Your Lordship. Ronald Kindia's uncle, which is situated in Lumkini, Umran, with the help of sniffer dogs from K9 Unit Shillong. On receipt of authorization, along with the accompanied staff and with the help of the sniffer dogs, conducted search of the premise in the presence of independent witnesses, Shri such and such, who have already deposed, Your Lordship. I read out the depositions. And the next paragraph, they state that at around 5:30, the sniffer dogs detected one aluminium box concealed in the bushes. At around 5:30. What do the independent witnesses say, Your Lordship? That the search was well over before the issuance of the authorization certificate as well. They say that it was over. PW says it was over by 1. PW3 says that it was over around 1 as well. He says that I left at 12. So it can safely be concluded, Your Lordship, that the authorization, these are all manufactured documents. Why? Because they were made after the search of the house. And the fact that the house was searched on the 30th, that is not even that has not even been spoken about by the police in the documents. Or neither in the punch number, neither in the FIR, neither in the charge sheet, Your Lordship. The fact that they searched the house on the 30th, police officers remained in the house on the 30th, they came back, they remained in the house on the 30th, they called back the witnesses on the 1st of July and searched the house before the arrival of the independent witnesses also, and the fact that the authorization was issued after the search of the premise and the house. All these factors have caused a serious dent in the story of the prosecution, Your Lordship. Further, let us also read, Your Lordship. Paragraph 15. I'll take you back to paragraph 15 of the petition. Now, PW1 is the complainant and he's a police official, Your Lordship. He himself stated in his in-chief in paragraph 8. I'll just read the relevant paragraph. At around 8 a.m., the search was conducted. He's speaking about the search of the house on the 1st of July 2023. He says, at around 8 a.m., the search was conducted. At around 1 p.m., the sniffer dogs gave a signal towards the jungle area at the entrance of the farmhouse. Thereafter, we proceeded towards the jungle area, and during the search, one iron box was recovered. Let us stop there. Interestingly, none of the independent witnesses spoke about the presence of a K9 unit or of sniffer dogs at the PO. Nonetheless, what comes forth through a perusal of the above quoted paragraph of the in-chief of PW1 is that the search was completed by around 1 a.m. on the 1st of July 2023 as well. Now, Lordship, when was the authorization issued? At 2:30 p.m. Panchnama also says the same. So, implying that the search was conducted after 2:30 p.m. Now, their own witness from their own department is saying that no, it was well over before that. Independent witnesses are saying the same thing. Your Lordship, because of these factors, one more thing has happened. It becomes apparent that section 41(2) of the NDPS Act has also been flouted. If I may, if your Honor remembers, and if I just make a mention, 41(2) empowers a gazetted officer to empower another officer above the rank of a peon in sepoy to search a premise. Now here, if you read the authorization certificate, it is apparent that it was issued at 2:30. So the search should have been started after 2:30 p.m. But here, a completely different narration is given by the independent witnesses and also by a witness who is from the police department, the complainant. He himself says that it was done well over before the issuance of the authorization certificate. Now, let me take you to para 18. I'll just read this out. That although it is pertinent, yet it must be asserted herein again that the entire prosecution story and case has become dented. The fact that the police searched the house on the night of 30th of June 2023 and did not make a whisper about the same in their documents, and that post the search of the residence on 30th June 2023, police officials stayed back in the residence of Bak India or the PO and asked the independent witnesses only to return the next morning, completely discredits the case and story put forth by the prosecution. Now, let us go into the material exhibits, Your Lordship. The witnesses could not even identify the material exhibits. Let me take you to para 19 of the petition. Further, PW3 could not even identify the material exhibits. He was shown all the material exhibits but could not identify the same. In para 15 of the cross-examination, PW3 stated, the material exhibits were shown to me today during my in-chief, however, I could not identify them.
Who is PW3?
Independent witness.
He was also a Caesar witness.
Caesar witness. So we have examined the Caesar witnesses, Your Lordship. These two are the Caesar witnesses who have signed these.
2 and 3 are Caesar witnesses.
That is what has given me an occasion to prefer this bail application. And let us not forget, remember, Your Lordship, when I read the FIR, it was alleged that 70 soap boxes were recovered. If Your Honor recalls, I had stressed on that point that the police have alleged that 70 soap boxes were recovered from the big aluminium box. Now they are even demolishing that particular fact. Let us go to paragraph 20, Your Lordship. Paragraph 20 of the petition. That further, both the Caesar witnesses categorically stated in the in-chief that they did not know as to how many soap boxes were seized in connection with the case, as they only saw 2 to 3 soap boxes being taken out from the tin box, and further that only 2 to 3 small boxes were open in their presence. PW3 specifically stated that he did not know what was inside the tin box. Tin box is material exhibit 1, Your Lordship, the big one. While PW3 failed to identify the material exhibit shown to him. As such, the entire prosecution case, as stated above, on these accords as well has become doubtful. Let us read the relevant portion of the in-chief and the cross-examination. PW2 stated in his in-chief, paragraph 9 of the in-chief, the police brought the box to the compound of Bak India, and placed one cloth on the ground. Then the police broke the lock of the box and opened the box. Inside the box, there were small boxes of the size of soap boxes. As there were many people who had rushed towards the place where the box was open, I could only manage to see 2 small boxes. I saw the police placing the small boxes in one place on top of the cloth. I did not see what the police did at the PO, as there were many persons who had gathered at the PO. Thereafter, I was asked by the police to sign on some papers. PW2 further stated in his cross-examination, it is a fact that I could not see the opening of material exhibit 1. I believe that must have been done, Your Lordship. The material exhibit, the tin box, should have been opened in the presence. He says, it is a fact that I could not see the opening of material exhibit 1. It is a fact that since I did not see the opening of the box, material exhibit 1, I do not know what was inside the box. It is a fact that on the day, I only saw 2 small boxes being taken out from material exhibit 1. As such, I cannot say if material exhibit 2 were recovered from inside the box. Now, Your Lordship, material exhibit 2 are basically a bunch of soap boxes which were showed to PW2 during his in-chief. I asked him, do you actually recognize these boxes? Because you had said in your in-chief that only 2 soap boxes were taken out in your presence. To which he said in paragraph 17, which I read out, as such, I cannot say if material exhibit 2 were recovered from inside the box. Lordship. Para 18, it is a fact that I did not see the police opening all the soap boxes exhibited as material exhibit 2. It is a fact that I do not know how many small boxes were recovered from inside the box, since the boxes were not counted in my presence. And finally, he stresses on this point again, the contents of only 2 small boxes which I had seen were shown to me. Now, PW3 also says the same thing, Your Lordship. PW3 stated in his in-chief, after some time I saw the police recover one big sized tin box from outside the compound of the house of Bak India and from inside the jungle area. Then the police brought the tin box inside the compound of the house and opened it. I saw the police taking out small boxes from the tin box, but since many public were gathered nearby the box, I could manage to see only 2 to 3 small boxes. However, I can no longer remember the color of the boxes. The police, on opening the small boxes, which were found inside the big tin box, found green powder inside the small boxes, Your Lordship. This also may kindly be taken note of, because I had referred to this. Police had stated that orange powder was recovered. He says green powder. PW3 further stated in his cross-examination, as I was standing at a distance, I did not properly see when the police opened the tin box. I only saw 2 to 3 small boxes being taken out from the big tin box. The material exhibits were shown to me today during my in-chief. However, I could not identify the same. I do not know how many small boxes were seized in connection with the instant case. I only remember 2 to 3 small boxes being taken out by the police from the big tin box. Only 2 to 3 small boxes which I've spoken of were opened in my presence. And Your Lordship, let me also assert So they have actually demolished the seizure at search and seizure formalities, Your Lordship. They have said that only 2 or 3 small boxes were recovered in the presence. Police is speaking about 70, they're saying 2. And the police is saying that they recovered the box in the presence of the witnesses, they're saying no. They're saying it was brought from outside. Lordship, one more point is that they have also categorically admitted, Your Lordship, that the weighing, testing, etc. was not done in the presence. Para 21, Your Lordship. I'll just read the portions from the depositions. Para 21, PW2 stated in his cross-examination, it is a fact that the testing and weighing of the powder was not done in my presence. It is a fact that I do not know the contents of exhibits P2 to P11, which he had signed, as they were not explained to me. I was merely asked to sign on the said exhibits by the police. PW3 stated in his cross-examination, it is a fact that I did not witness the preliminary testing and do not know the result of the preliminary test. It is a fact that I do not witness the weighing process either. I do not know as to who was authorized to search the house of Bak India, as no one was introduced to me as an officer authorized to search the house. It is a fact that the contents of exhibits on which I signed were never explained to me. Lordship. So this process also was not done in the presence, Your Lordship. Lordship, let me also take you to paragraph 22, wherein actually again a reference has been made to the identification of materials by PW 2 and 3. Let me just read out the relevant portions. It will not take me more than 10 minutes to conclude, Your Lordship. I'll just take 10 minutes more. PW 2 stated in his in chief, that is under paragraph 22, Your Lordship. Paragraph 22, so I state therein, PW 2 stated in his in chief, material exhibit 3. So, Lordship, again here I must tell the court, material exhibit 3 was basically a plastic in which there was some powder. Some powder was there. When I asked him about these things, he stated this in his in chief itself, Your Lordship. He stated in paragraph 27, material exhibit 3 is one transparent polythene bag where the powder looking like pig feed is kept. PW2 further stated in his cross-examination, the color of pig feed is white. It is a fact that material exhibit 3 is not white in color but yellow. So what he's saying, that something which was seized in his presence was white. I mean, the powder which was recovered from those 2 to 3 soap boxes which were shown to him, now that powder was white in color. During his cross, he says that what is being shown to me today is something yellow in color. And PW3, Your Lordship, he says, I'll take you to page 18. So PW3, with regards to the color of the powder, says the police, on opening the small boxes which were found inside the big tin box, found green powder inside the small boxes. One witness is saying white, the other saying green, the police is saying yellow. Who do we believe here? And they did not even witness the testing and the weighing. How do we know that what was recovered on that particular day? That too again is in question, because they've only shown the contents of 2 soap boxes. So whether the contents of those 2 soap boxes were contraband or not, how do we know now? The color is disputed, the testing is disputed, the weighing is disputed, Your Lordship. Not by me, by the witnesses themselves in the in-chief. And I just asserted on those points during my cross-examination. Your Lordship, I'll take you to para 23. Now, if your honor recalls, I've spoken about a big tin box from which 70 soap boxes apparently were recovered. Now, that sealed box, that material exhibit 1, it was marked as material exhibit 1, the big tin box. Now, when it was brought to the court, it was in an open state. I asked the witness this and he admitted to the same, Your Lordship. Para 23, PW2, stated in his cross-examination, it is a fact that when material exhibit 1 was shown to me today, it was not sealed and locked, it was in an open state when it was shown to me. It is a fact that my signature does not appear on material exhibit 1. It is a fact that I cannot say if material exhibit 1 is the same tin box which was brought by the police at the PO, since the same does not bear my signature. It was in an open state. At least the least they could have done was marked and sealed. That also was not done. Now, Lordship, with regards to the recovery, paragraph 24 is probably the most important paragraph, and I'll read out the entire thing, Your Lordship. It will take me just a couple of minutes. Please let me read paragraph 24. That further, the witnesses also stated that they did not personally see the recovery of the tin box, or from where. Are we there, Your Lordship?
Yes.
I'll start reading it. That further, the witnesses also stated that they did not personally see the recovery of the tin box or from where the police brought the tin box. They also admitted that the police brought the tin box from outside the compound and premise of the residence of Bak India, and that particular area was accessible to anyone and everyone, and that the tin box brought by the police could have belonged to anyone. The witnesses also admitted that the accused persons were not present during the house search on both the days. Let me read specific portions. PW2 specifically stated in his in chief in para 8, The police found one tinted box from outside of the compound of Bark India, which was hidden in the bushes. PW2 further stated in his cross-examination, it is a fact that even on 1/7/2023, nothing was recovered from the house or from the premise of the house. It is a fact that nothing was recovered from the premise of the house as well. It is a fact that the tin box material exhibit 1 was brought by the police from outside the compound of the house from a jungle located adjacent to the house. It is a fact that the jungle is accessible to everyone. It is a fact that I did not see as to from where the police recovered the tin box. Your Lordship, if this may be marked, this particular has a lot of relevance because the recovery at least must be made in the presence of the witnesses. He says he does not know as to from where it was recovered, Your Lordship. Further, he states, Your Lordship, in para 26 of his cross-examination, it is a fact that when the house search was conducted on the 30th of June 2023 and 1st of July 2023, the accused persons were not present at the PO. It is a fact that material exhibit 1 was brought by the police and that too from outside the house of Bark India. It is a fact that the accused persons did not lead to the recovery of material exhibit 1. It is a fact that the material exhibit could belong to anyone as it was recovered from the jungle. I cannot say material exhibit 1 belonged to the accused persons. It is a fact that the formalities which were carried out by the police were not explained to me. Now, the other Caesar witness, Your Lordship, PW3, he says, para 9, it is a fact that on 1/7/2023, as well, nothing was recovered from the residence and compound of Bark India. It is a fact that nothing was recovered from the surrounding of the residence of Bark India as well. It is also a fact that the tin box which I spoke of in my in-chief was brought by the police themselves from outside the residence and compound of Bark India. It is a fact that I did not see from where the police recovered the tin box. He further stated in the cross-examination, it is a fact that the accused persons were not present during the house search conducted on 30th of June 2023 and on the 1st of July 2023. It is a fact that the tin box was not recovered on the leading of the accused persons, obviously because they were not present, Your Lordship. It was brought by the police themselves from outside the premise of the residence of Bark India. It is a fact that the formalities carried out by the police were not explained to me. It is a fact that I did not witness the packing and sealing of the article seized. I cannot say if the tin box belonged to the accused persons as it was brought by the police themselves from outside the compound and residence of Bark India. And finally, the place from where the tin box was brought is accessible to everyone. As such, the tin box could have belonged to everyone. Lordship.
To a certain extent, you have proved your point.
Lordship.
But that, you see, again, that would be a subject matter of evidence, of appreciating the evidence when it comes to that. And that will be by trial court.
No, Lordship, again, I must assert that now when we look at the materials on record at this present juncture, when I'm preferring this bail application, what we must do is prima facie, we must form an opinion. The court must form an opinion. And how can that be done, Your Lordship? That can be done only through a perusal of the documents on record and the depositions of witnesses which have already been recorded. Now, the prosecution witnesses, the Caesar witnesses, who are probably the most important witnesses in an NDPS matter, they have themselves said that the house search was conducted on the 30th of June. The police do not make a whisper about the same in their documents. And the police officers stayed back on the same night and called them to come the next morning. And next morning also nothing is recovered. They demolished the Caesar of 70 soap cases as stated by the police in the FIR. Further, even PW1 says, Your Lordship, that the search was conducted prior to the issuance of the authorization on the 1st. He doesn't speak about the 30th. The fact that the house was searched on the 30th itself causes a dent in the prosecution's case, Your Lordship. Lordship, now would the rigors come in the way? They wouldn't, Your Lordship. They actually get diluted. Now, I don't say this on my own accord, Your Lordship. I'll just place the judgment of the Honorable Apex Court. Now, Lordship, this judgment, of course, in this particular judgment, a bail application was preferred. Amongst other interpretations, interpretation of 2037 was also made by the Honorable Apex Court. The citation is given on top of the page, Your Lordship. Let me read. The heading, I've already underlined that. Held, special conditions as enacted under Section 37 can only be considered within constitutional parameters when the court is reasonably satisfied on a prima facie look at the material on record that the accused is not guilty. A plain and literal, there's a word missing. I'm just reading the heading, sir. A plain and literal interpretation, I believe, Your Lordship, would effectively exclude grant of bail altogether. Further, held appellants deserve to be enlarged on bail. Let me take you to the relevant portion, Your Lordship, which is at paragraph 18. Para 18. Now this is interpretation with regards to 37. I'll start reading. Para 18. The conditions which courts have to be cognizant of are that there are reasonable grounds for believing that the accused is not guilty of such offence and that he is not likely to commit the offence while on bail. Now, what is meant by not guilty when all the evidence is not before the court? It can only be a prima facie determination that places the court's discretion within a very narrow margin. Given the mandate of the general law on bails, sections 436, 37, and 39 of the CRPC, which classify offences based on the gravity and instruct that certain serious crimes have to be dealt with differently while considering bail applications, the additional condition that the court should be satisfied that the accused, who is in law presumed to be innocent, is not guilty, has to be interpreted reasonably. Further, Lordship, in paragraph 19 it holds, a plain and literal interpretation of the conditions under section 37, that is, that court should be satisfied that the accused is not guilty and would not commit any offence, would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special conditions as enacted under section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record whenever the bail application is made. Lordship, this may be taken note of. Whenever the bail application is made, that the accused is not guilty. Any other interpretation would result in complete denial of the bail to the person accused of offences such as those enacted under section 37 of the NDPS Act. Para 20, Your Lordship, the standard to be considered therefore is one where the court would look at the material in a broad manner and reasonably see whether the accused person's guilt may be proved. We'll stop there, Your Lordship. Now, because of whatever I have read, the absolute demolishing of the case by the prosecution witnesses themselves, the independent witnesses, can we actually not safely conclude now that probably the case would head towards an acquittal and that the guilt is not proved? Let us actually supposedly take a situation where the IO of the case comes, the seizing officer, and I don't cross-examine him. Would the court, while passing the judgment, not look at the deposition of the witnesses, of the independent witnesses who have demolished the case? It would. So at this present juncture, when I'm making this application, Your Lordship, and that is also stressed upon in this particular paragraph, whenever the bail application is made, is Your Honour primarily satisfied that the accused person's guilt may not be proved? I believe it has to be answered in the affirmative. Why? Because of the demolishing of the case by the seizure witnesses themselves. So this is the interpretation of 37 given by the Honourable Apex Court. Lordship, one more judgment which I would like to refer. Lordship, this is an order passed by your good self on the 11th of March 2025. Now, what had happened in this case, Your Lordship, after the examination of one witness, Your Honour, on prima facie being satisfied that no conscious possession could be proved, granted bail to the accused. Let me take you to the relevant paragraphs. I'll take you to paragraph 3. Accordingly, a case was registered at Clariat Police Station under sections 22C of the NDPS Act. After the completion of the investigation, the IO in due course filed the final report, including the charge sheet, with the opinion that the prima facie case under section 22C. Same situation, Your Lordship. 22C is found well established against the applicant herein, and he is made to stand trial. So I'm basically referred this. Why? Because this is also a case under commercial quantity. Now I'll take you to paragraph 12, Your Lordship. The concluding paragraphs basically start from paragraph 12. Excuse me. Para 12, Your Lordship. While considering the case of the parties herein, the applicant admittedly is in custody for more than 1 year, 4 months, being accused of committing an offence punishable under section 22C of the NDPS Act. Lordship, the accused herein, who's in question, I'll just stop there, Your Lordship, if it's all right. This particular individual on whose behalf the bail is preferred, he's in custody for 2 years, 2 months, more than the period undergone by this particular individual. I'll read para 13 now. Admittedly, the stage of the case is for recording of the evidence of the prosecution's witnesses, stated to be 12 of them, with 1 witness dropped and 1 being examined as PW1. The applicant had preferred 2 bail applications before the trial court, which were rejected for the reasons stated in the related orders. However, it may be reminded that for an offence punishable under section 22C of the Act, any prayer for grant of bail would attract the provisions of section 37 of the said Act. It is well settled that an accused person charged for an offence involving commercial quantity of contraband shall not be released on bail unless the public prosecutor has been given an opportunity to oppose such application if made. And secondly, if the court is satisfied that there are reasonable grounds to believe that he is not guilty of such offence, only then can bail be considered. Section 37 reads as follows. I'll not read that, Your Lordship. It's fine. I'll go to para 16 now. Facts of the case as indicated above need not be repeated. However, this court has observed that the prosecution has not been able to definitely pinpoint the fact that the said backpack containing the contraband substance was seized from the conscious possession of the applicant herein. Lordship, again I'll stop here. The reason why I'm stopping here is because here the court had taken note of the fact that the backpack containing the contraband was not in the conscious possession of the applicant. In our case, conscious possession, determination of whether conscious possession is there or not would only come if the search and seizure is accomplished. Only after search and seizure is accomplished would the question of whether the accused was in conscious possession or not would come into the picture. Now here, after perusal, I have read out the deposition of the witnesses, Your Lordship. They have demolished the search and seizure formalities only. So the question of interpreting whether conscious possession is there or not, that doesn't arise itself. So in terms of bail, I believe this particular individual, Ronald Kindia, on whose behalf the application is preferred, is on a higher pedestal than the person to whom Your Honour had granted bail. I'll read further, Your Lordship. Para 17. The learned PP has placed heavy reliance on the evidence of PW1 to say that the witness has clearly stated that the said bags were seized from the possession of the applicant herein. However, the learned counsel for the applicant has pointed out that this witness in his cross-examination has also stated that he has no knowledge from where the contraband was seized. From inside the truck. At least he tells the location that it was seized from the bus, but from where he doesn't know. In our case, Your Lordship, it's completely different matter. The entire search seizure formalities have been demolished. From inside the bus. And also that the same was not found from the physical possession of the applicant. At this juncture, what can be construed is that the seized contraband was not found from the conscious possession of the applicant. At this point of time, this court is of the considered opinion that there is reasonable ground to believe that the applicant is not guilty of the offence alleged. Thus, the embargo imposed by Section 37 as far as consideration of bail is concerned is lifted under the facts and circumstances. Time and again, the Honourable Supreme Court in a catena of judgments has liberally considered the grant of bail to an accused involved in offences under the NDPS Act, where the provision of Section 37 is invoked on the ground that the accused person has been incarcerated in custody for a prolonged period of time and the trial seemingly would not complete in the near future. This is one such case under the category. Satisfies both those accounts on which Your Honour had granted bail to the accused, Your Lordship. Prima facie case not being established. Actually, on that ground, the accused person is on a higher pedestal. Search and seizure formalities have been completely demolished. The question of whether he was in conscious possession will only come in later. Here, the entire search and seizure formalities have been demolished, Your Lordship. And he's in custody for a longer period than this particular individual. Hence, I pray for consideration of bail.
Lordship, I'll just take Your Lordship to the page 46 first, the previous order. Factual situations are a bit different from both the cases, so page 46, if I just come to page 45, para 10. Yes. The previous order. Yes. So in the first round, Your Lordship, the issue of delay was raised. The issue of delay was raised, and so the court had considered, Your Lordship, para 10. The specific order passed on 21/3/44/2025, and court has quoted all the dates. Observed as a whole would show that some dates witnesses were present in the court, certain dates the presiding officer was on leave. Nothing is noted to indicate that there was any lapse on the prosecution to take steps in the matter. Accordingly, it may be noted that the trials have been not to be said that the trials have been delayed unnecessarily. This being the case, the court is convinced that the petitioner has not been able to make out a case for grant of bail on account of delay in the proceedings. Authorities cited with due respects are deemed to be applicable, the peculiar facts and circumstances case in the hand. So, Lordship, in first round, the issue was raised of delay, and court read out the order and found that there was no question of delay has been made out. Why I read out this order, Lordship? In this case, my learned friend has relied on our Lordship's judgment. I'll just start from that and then we'll come back to it. I will not take much time, but
He has gotten threadbare, so I have to reply a bit. So, Lordship, in this case, Sanju Singh was the issue where court was dealing with conscious possession, and the issue of black was involved. So, conscious possession is a very serious issue in DPS Act, and also coupled with issue of delay. So, court in that case is distinguishable because the issue of conscious possession and delay. This present case, issue of delay has been addressed in the last round. He is not following up. One
Stressing
minute. You have done it. Maintain some.
True.
Please. It's not wise for me to remind you.
Right.
So, Lordship, the issue of conscious possession and delay was the subject matter of Sanju Singh. Sanju Singh is not applicable because court had, while considering conscious possession, also had addressed the issue of delay. In this case, my first submission, Your Lordship, is that delay is not addressed. There are two witnesses examined, and if you confine this case, it's a commercial quantity where the issue is Caesar witnesses contradicting. So, Lordship, we have to consider this case afresh. What will happen if the Caesar witnesses contradict or say something different, and then what will be the consequences? Lordship, first of all, 2012, Your Lordship, once I can give a copy of the judgment later on. It was in a different context. The law is very settled that pre-charge sheeted argument on section 37 stands in a different footing from post-charge sheeted. I did not stop my learned friend because I thought let him go ahead with the analysis of witnesses. The issue in entire argument was the Caesar witness and where they have said what they have said, whether it's contradictory, whether it's doubtful. 2012, Your Lordship, the law is settled. I don't have a copy. I just got it from my.
What's the citation?
Citation is 2012, Your Lordship. Of course, in a different context.
2012 what?
2000. I'll just give you, Lordship. 2012 8 SSC 795.
7-9. The name of the parties.
795.
Vilas Pandurang Pawar and others versus State of Maharashtra. Important issues lordship has been laid down here. Of course, it was an SC/ST case anticipatory bill, but the proposition of law laid down is very important, Lordship. Moreover, while considering an application for bail,
No, under the ST/SC Act, any similar provision as in section 37.
no, Lordship. I'm just bringing out this ratio of law. Let what is the power of the court for considering of bail in a charge sheeted cases. The ratio of the law is this part, Your Lordship. The language of the judgment is, moreover, while considering the application for bail, scope for appreciation of evidence and other materials on record is limited. The court is not expected to indulge in critical analysis of evidence on record. So this was the ratio laid down, though the context was SC/ST anticipatory bail. But this ratio was very important. While considering bail, court is not expected to appreciate evidence and other materials on record. Is very limited. The court is not expected to indulge in critical analysis on evidence on record. Now, let me straight away come to para 7, page 14. Whether page 15, Lordship. Let's come to page, Lordship. Let me start from page 14. Page 14 first, 9, PW29. Whether court will indulge in critical analysis of the evidence, though our bigger context is Caesar witness only. Caesar witness. Page 14, para 9. The police bought the box in chief of PW2. The police bought the box in the compound of bar so-and-so and placed one cloth on the ground. Then the police broke the lock of the box and opened the box. Inside the box, there were small boxes of size of small soap boxes. As there were many persons, this is very important, Lordship. There were many persons who had rushed towards the place where the box was opened. I could manage to see only 2 small boxes. This is an in chief. This has not been shaken, and we will come to page 15 in Lordship. Again, PW3 in his in chief 7. After some time, I saw police recovered one big size tin box from outside the compound of the house of Ba India and from inside the jungle. He's an eyewitness. He's an eyewitness who saw. PW3 is an eyewitness who saw from compound. There's no issue of residence or premise. A very lengthy argument was forwarded saying that nothing was recovered from the residence.
You see from outside the compound.
Yes, outside the compound and the house of so-and-so and from inside the jungle. Then the police brought the tin box inside the compound of the house and opened it. The opening was done when the tin box was brought inside. Caesar witness will come only when the box is opened. So I'm on to that, Your Lordship. The police then brought the tin box in the compound of the house and opened it. I saw the police taking out small boxes from tin boxes, but since many police public were gathering nearby the box, I could manage to see only 2 to 3 numbers of small boxes. However, I can no longer remember the color of the boxes. Not remembering is not fatal, Your Lordship. Lordship has dealt with it in a number of other cases. The police, on opening the small boxes, which was found inside the tin boxes, found green color powder boxes, small boxes. Lordship, whether it was green or yellow or white, sometime because there were, as I read out para 14.9, there were a lot of people. He peeped into it. Lordship will have to make a distinction when a Caesar witnesses. Normally in an NDPS matter, what happens when the police seizes? They inform the local headman. Local headman or his deputy comes. So clear direction who comes, what is to be done. Here, Lordship, there are a lot of people being rushed. Minor variation in color, which is a subject matter of trial, where the police comes in the witness box, he can ascertain, or whether none of the witnesses says, that is a matter of trial. So admittedly, this part, seeing boxes, powder, compound brought in, is on record. And Lordship will just come now, page 79, straight to the page 79. Para 2, Panchnama.
Yes.
This is a very important document, Panchnama, para 2. Around 5:30 p.m., the sniffer dogs detected one aluminium box concealed in the bushes, suspected to contain illicit contrabands. The box was opened in the premises of GD and witnesses and found 70 numbers of soap boxes were found to contain suspected contraband inside. If I try to connect page 14, para 9, 7 and Panchnama, I mean, Lordship, it will become like a full-fledged hearing. Full hearing, Lordship. Because at this stage, as I submitted, Lordship, critical analysis of evidence in a charge-sheeted matter, court will not go into it. His case is only on the Caesar witness. Now, Your Lordship, since he raised the issue, imagine a situation now. If the Caesar witnesses, he's reading out the contradictory part. Imagine the Caesar witnesses turns hostile. Then what happens? Forget about the contradiction. Forget about he disowning and he doesn't know it.
Whatever the case may be, you see, the seizure witness
Lordship.
have been examined and discharged.
Lordship, yes.
Nothing has, nothing has turned out that they were hostile.
Absolutely. Lordship, I'm presuming a situation. Why Caesar? My purpose in seeing what happens to hostile is a Caesar witness. At this stage, only by relying on Caesar witness, a case of 37 or case of prima facie cannot be decided. My purpose of saying is that because even if he turns hostile, there are other witnesses, because the Panchnama and the other witnesses clearly says from where it was recovered, where it was bought, and what was found inside. This is prima facie on record.
See, Mr. Khan,
Lordship.
let us understand the character of a seizure witness.
Yes.
Who is a seizure witness? Number one, he is an independent person,
Correct.
not related to any of the
Absolutely.
parties,
Absolutely.
not even known to the police. He must have been picked randomly. Since he was, they or he was in the vicinity.
Large number of people came, he was one of them.
So police say, come.
Come, yes.
This is,
We know,
this is what happened.
Lordship, we are dealing with it. In almost every cases we deal with it, yes.
Can you certify that this thing, has happened and this is what we are doing?
Yes, absolutely. Absolutely.
It is assumed that he would be dependent. He would state facts.
Yes.
Perhaps not even, more often than not, he would support the prosecution's case.
Yes.
So that is what we
Normally,
presume.
Your Lordship, normally.
That is what we presume the character of a seizure witness would be.
Yes.
Here, seizure witness have come, they have stated facts as they see it.
Yes.
So if it is contradictory to your case or not in accordance with what you would like to portray,
Lordship.
so be it.
Lordship, absolutely. But that will that. The issue is this: will that? Are we arguing on a final hearing for acquittal?
Yes, that,
Lordship, yes.
like you said, see, that would be, you see,
Yes.
their evidence would have to be way
Three. There are 10 witnesses. 3.
along with others.
Lordship, I'm sorry. I think I prejudged my submission. When I was referring to hostile. Supposing the seizure witnesses are not there, they for some reason they don't come. Will the trial collapse? No. Panchnama in the police. He saw the police bringing. Now, Lordship, that is very, very important. He saw the police bringing. Police witness is very important. Police witness is very important. No, that stage has not come. Where is the occasion for the court to critically evaluate the evidence? Now, number 1. Number 2, only the issue of seizure witnesses come. And out of 10, if 3, for some reason he can shake, supposing the seizure witness is shake, will the prosecution case collapse? Or will the issue of prima facie will be decided against the prosecution at this stage? Especially when I read out para 9 and 7 where clearly PW3 say he saw the police coming. No, he's seeing the police coming from outside the compound, bringing the box, opening the box and the content. Now, if this seizure witness for the sake of argument, if they were not examined, they went hostile or they choose not to come to court. Who will prove the seizure, Your Lordship? 1978, Your Lordship, this law has been settled. I had argued in another matter, Your Lordship will recollect in that Burnett Lingdos matter. Even if seizure witnesses don't come, they turn hostile is immaterial if there are other witnesses to support. Only in the final hearing stage, Lordship, in the final hearing stage, if the situation...
They say that will be in the final analysis.
Lordship, in the final hearing stage, if the seizure witnesses turn hostile, they contradicted, and the police are vague on that, the benefit of doubt will be in favor of. So, not for the purpose of prima facie can you rely on an argument only of seizure witness and says the rigor of 37 has to be diluted. The issue of prima facie stands dented, stands doubted because of that. My submission, Your Lordship, only on the basis of seizure witness, no. Assume a situation, they don't come, they turn hostile, they refuse to come, they came and says, no, nothing happened, police, supposing they come and say, Lordship, they come and say, police forced them. Lordship. And then, Lordship, in the matter of trial, the police statement is crucial whether he was forced or not. In worst situation, Lordship, the court can overlook entire seizure witness, except if they have to prove that is very, very fatal in the NDPS matter. But if there are other witnesses to show, this particular 3 in the in-chief has said, I saw this thing happening. So, Lordship, my submission here is this.
You've made your point.
Lordship, my submission here is this, only on the ground of seizure witness. Only on the ground of seizure witness, court will not critically examine the evidence. If at all the entire submission he made is a submission required at the time of final hearing, when all the 10 witnesses are examined. And the judgment that he relied on, Lordship, 37, Lordship, that was a judgment that came out from delay. As I submitted, our issue is not delay. This court is already handled and there is no material to show from the date last order till now. In other words, he forwarded an argument saying the other 2 witnesses were examined. He has abandoned the argument of delay. No, the only limited argument is prima facie on the basis of seizure witness. The embargo is very clear, court will not critically weigh our argument. The entire argument he forwarded is premature, not fit for bail. Prima facie, para 9 and 14 of page 14 and 15 clearly shows there is evidence on record, which shows clearly. All other contradiction is a matter of final hearing, not at this stage. So this is not a case for bail, Lordship.
Lordship, if I may have a few rebuttals on law points, of course. Now, sir, of course, Leonard, sir, has referred to few paragraphs from the depositions. And I would say those were piecemeals. You can't just pick a particular line from there and place it together. What I've done is I've read the entire in-chief almost and the entire cross-examination. And a perusal of their depositions, including the in-chief, shows that the entire prosecution case or the prosecution story or the seizure is dented. Why? Because the prosecution witnesses themselves say that on the 30th, the police searched the house, remain in the house and call them the next morning. And the next morning as well, Nothing was found from in and around, and the police brought. He's relying on the word brought. They saw the police bringing. And your lordship also correctly took note of the particular point that outside. The box was brought from outside the compound. And they have stated in the concluding paragraphs of the cross, which I've also read, your lordship, that they did not see the place from where the from where the box was recovered. And a few points more, your lordship. Now, sir has actually brought out the point of hostility. I mean, I need not remind again, but if that is to be raised at all, it must be raised when they were being examined at that particular point in the trial court. Right. I must say though. Correct. Now, I am going back to the facts. Because, sir, you have praised peace means. That is why. Lordship, now again.
We are well aware of how and when witnesses is declared hostile.
Now, lordship, again. Now, when sir says about Caesar witnesses, I believe I just took a mention of it, sir, and I wrote it down. He says the Caesar witnesses come into picture after the recovery of the substance. No. Is this a case under chance recovery? Again, a distinction must be drawn, your lordship. The two types of recoveries made in an NDPS matter. Chance recovery, where the police recovers the contraband, calls for the headman. This is a case of source information. They had prior information as to where the contraband was kept. Here, the statement and the deposition of the witnesses are of prime importance. And it is clear in paragraphs, your lordship, again I'll mention paragraph 6 of PW1's deposition, where he states that the police instructed me to report on the first. The other witnesses also states that the police instructed me to report on the first at this particular point of time. So when they arrive, shouldn't the search and seizure formalities be completely carried out in the presence? No. They say that it had already started before they reached. They say that the police brought the box from outside the house. So if they were present there, but they're not denying the fact that they were present, of course. And now when they say that the police brought it from outside, and they don't know from where exact location, should that not be taken into consideration?
You're repeating your submission.
No, I'm not, your lordship. I'm only raising this why? Because sir has actually caused... Sir has brought this point up that they're only important from the point of recovery, but that would only be applicable in chance recovery cases, not in such cases. Lordship, one more point. This is a law point, of course. Now, sir had read out a judgment of the Honorable Apex Court.
That is not in. He is yet to supply that judgment.
Yes, Lord, yes. Lordship, is a settled position. Basically, what my purpose of reciting that was, court will not critically. We'll give it the copy. The court will not critically analyze.
Lordship, one thing, just on that particular accord as well. Now, sir has placed basically a judgment on anticipated bail in an ST case. So what I've placed before your lordship, and let me read it again if I must, that the interpretation of section 37 has clearly been given by the Honorable Apex Court in this particular judgment, which says whenever the bail application is made, the court must be prima facie satisfied as to whether the accused person's guilt is made out or not. And finally, lordship, on this accord as well, the judgment which I had relied on, which I had placed before yourself, Sergeant Singh's, which your honor had passed. Now, sir had said that basically the contention there was something else and it was in delay. No. The court, even in that case, your lordship, in paragraphs 12 to 17, which I've already highlighted first, because it was a case under commercial quantity, basically satisfied itself that the accused person's guilt was prima facie not established. And then only, your lordship, your honor proceeded to grant that person bail. It held that conscious possession was not established, only establishing that your honor granted him bail. Additionally, you had also noted that, of course, there is delay, but the prima facie consideration before the court on that particular time was 37 of the NDPS. Hence, that is also applicable.
So, about the parties?
Lordship needs a copy. We'll just give it during the course of the day. Para 12. Sorry. I just relied on the iPad, Lordship. I didn't.
I'll pass this yours.
All right.
Item number 2.
Can you handle number 2? Oh, sorry. This supply, right? Sorry.
Yes.
Yes, please, Your Lordship. Your Lordship, I am here for the this application under section 5 of the Limitation Act. Your Lordship, before starting, Your Lordship, I just gave a small correction in paragraph 3, Your Lordship. There is some typing mistake. It does not come in my eyesight, Your Lordship, earlier. Paragraph 3.
Yes.
This will be, Your Lordship, in the below latter part of January 2025 it is become piping years 15 years. So this was not in my,
Should be 25.
it will be 25 years. Because I applied for certificate December 24 and later about to January. So here you will see, I filed this petition before this honorable court against the order passed by the Special Judicial Officer in 9/12/2024. So here you will see this order was passed on 9/12/2024 and 10/12/2024 I applied for the certificate copy and I got it in 19/2/2025.
What is the first, Mr. Devnath? You tell us, or you tell me, what is the background facts of this case?
So, background of the fact the case is you will see this uncle of the petitioner, he was the owner of the plot of land and land was recorded by the government, and subsequently the petitioners and his brother has informed to the deputy commissioner that his uncle is no more, so they requested to include their name. So what happened subsequently, the reference was made before the special judicial officer, then his uncle name was there, and knowing about it, the petitioner here and his brother.
No, reference was made in the name of the uncle,
Uncle.
okay,
Who is no more.
who was already expired by the time.
Yes, and it is in knowledge of the deputy commissioner. So what's happened, you see, that subsequently petitioner and his brother, now deceased, both of them approached before the special judicial officer for implement them as a necessary party. So what's happened there, you will see, the petition was signed by both the petitioner and affidavit was shown by one of the petitioner. So after hearing what's happened, you will see, the petition was rejected and it was not known to this petitioner. When subsequently appeared, then they came to know the technical ground was there, that petition was not signed by the affidavit was not signed by both the petitioner, so that's why it is rejected. So when he came to know, immediately he has applied for certificate copy and obtained the certificate copy and then filed the petition for review. So after this, you will see this opposite party has raised the objection from other ground, but didn't mention about the limitation and others. And when finally going to be decided this matters, whether it is correct or not, review petition, then question has come for limitation, that it was delayed because about 3 months it was delayed, could was not sitting, and after that they came to know. And then if you consider even from the date of knowledge and apply for the certificate, then this review petition was within the time, no need for this. So when this hearing was took place, then this on the basis of the objection when raised in the finally, then this is either to let us withdraw this petition and file in proper. If it is not, could allow and could reject the review petition. So I am here before this honorable court from the rejection of my petition by the special judicial officer at the moment. So here when I have applied for certificate on 10/12 and I got it in the month of February 19. So you will see when I prefer this civil revision here, then I feel because of this delay in obtaining the certificate, if you consider, then there may be some impasse in this matter of hearing. So I filed this application for the purpose of granting the condemnation of delay for filing this review petition, considering the date of order pass. So you will see in this case, If I take the date of the order passed by this special judicial officer, then there is 18 days delay.
18.
18 days, 1 8. But if I consider this one, that whatsoever the date has taken to obtain the certificate copy, then there is no delay. So this is my case. So then question is come where I filed the petition of continuation delay. So I feel, Your Lordship, if this at the time of hearing come up, why didn't explain to the court? Why has prevented and it is more than 90 days? Then I will not be having any explanation. So due to this, I filed this petition, explaining these matters, what's happened and what is the matter thereof. So this is the explanation is given in Your Lordship, paragraph 4 onward. And the 3 onward second, Your Lordship, may I read, Your Lordship? That the humble petition beg to state that as per section 12(3) and 4 of the Limitation Act, the
Reading
paragraph 3.
3. Yes.
That the humble petition beg to state that as per section 12(3) and 4 of the Limitation Act, the period required to be obtain the copy of the order is exempt from Limitation Act, that is for the period of limitation for 72 days. The court was closed for winter holidays from the middle of the December 2024 till the latter part of January 25, and the petitioner could not get the certificate copy in the order on 9/12/2000 from the Learned Council on 19/2/2025.
Yes.
Then paragraph 4 is that the humble petitioner beg to state that the civil division petition was filed within the period of 90 days following date of the order, and the same ought to have been filed within 90 days, that is within 8/3/2025. So if I consider this one that's within 90 days, then it was in 8/3/2025 within the calculation of period of required to be obtained the copy of the order. If the period of 72 days required to obtain the certificate copy of the order dated 9/12 which is exempted to civil court filed by the humble petitioner is within the time. So I says, you receive, if this certificate copy obtained and this period is considered, then in my petition is within the time. Then paragraph 5. That the humble petitioner beg to state that his elder brother C. Mantus Kharsandi expired on 1/3/2005 and family bereavement, and the humble petitioner could not file this civil petition within the time and time required for filing the civil petition by the humble petitioner. So in between, Your Lordship, even his brother also expired. Then paragraph 6. That the humble petitioner could file the petition on 18/3/2018, but the petition returned for certain defect and needed corrections and filing fresh, and petition could be filed only on the date of presence of the court, cause 18 days delay without considering the period required to obtain the certificate copy of the order 9/12/2024. So I am clearly stated here, Your Lordship, that if the period obtain the certificate copy, if I even include, then there will be 18 days delay, and if I exclude this, and it is within the limits. This is my petition.
So if you exclude the period of obtaining the certified copy,
then it is within the time.
What about this 18 days?
18 days because from the considering the date from the date of order and till the date of filing of the petition.
Okay.
As a whole, if I take as a whole, then there will be 18 days delay. So I didn't take this any risk of it, Your Lordship. So that's why I filed this petition. Otherwise, it is within the limitation, Your Lordship.
So if you concede that there is a delay of 18 days,
18 days.
what are your grounds?
So the ground is, Your Lordship, this paragraph whatever stated, this is the only the ground, Your Lordship.
You must show sufficient cause.
This sufficient cause is there, Your Lordship. This one is sufficient cause is there, Your Lordship. I have applied for certificate copy. I didn't get the certificate copy in time. And another is my brother was expired, and after this there was a bereavement in the family, and due to this I was.
Okay, let's come again. The impugn order was 9/12/2024.
Yes, Your Lordship.
9/12/2024.
Yes.
Okay.
And obtained the certificate on 19/2/2025.
You obtained certified copy on.
19/2/2025.
Tell me, when did you apply for certified copy?
On 10th December 2024.
Okay, the next date.
Yes, Your Lordship.
Certified copy 10/12/2024. Then you receive certified copy on
On 19/2, 19/2, Your Lordship.
19/2. Okay. Now, (19/2 2024). So when did you file the this application?
In 24th March, Your Lordship, it was registered on 24th March. Before they presented it was
24th March.
in 24th.
So this application was filed on 24th March.
Yes, 2025.
So you have to calculate from 19/2/2024 to 24 March.
This will, but I have calculated from the date of 9/12. I have taken into consideration from this date of passing the order.
9/12.
Yes, Your Lordship.
What is see, application for certified copy? That
That will be
that period will be excluded.
After excluding this one, you will see within the time.
From 19/2 to 24/3, how many days are there?
Then it will be 1 month, some 5 days.
And period for filing the petition is within 3 months or
Within 3 months, 90 days.
3 months.
3 months.
Okay. So again, if you have taken the period from 9/2
Yes.
or 9/12,
9.
if you say from the date of the impugn order,
Yes.
9/12
Yes.
till 24/3, then delay of
18 days. 18 days. 18 days.
excluding period of holidays.
Yes, Your Lordship.
Okay. Yes. Anything else?
So, Your Lordship, as because Your Lordship, we are having that section 12 of these limitations, and in this respect, the matters, Your Lordship, regarding this section 12, Your Lordship, this, there is one judgment from the Honorable Guwahati High Court in full bench. Your Lordship,
What does Section 12 says? How is it applicable to your case? How is Section 12 applicable to your case?
for the this period of limitation, how to be excluded the obtain the certificate. Paragraph
You
12.
read out Section 12. What does it say?
Section 12, this exclusion of the time in legal proceedings, this one. Then after that, you will see this subparagraph 3, where a decree or order is appealed from or sought to be revised or reviewed, or where an application is made for leave to appeal from the decree or order, the time requisite for obtaining the copy of the judgment shall be excluded. So,
That is well settled.
so this judgment also this is on the full bench. It is given that if even the order pass and subsequently decree pass, and if this person apply for the certificate copy and subsequently decree come out, but limitedly start from the date of the order. So this is the matter. So in my case also, I have applied for certificate copy. I didn't get the certificate copy, and for this particular was 72 days, whatsoever time taken for obtaining the certificate copy, it should be excluded. And on excluding this period, then my petition is within the time.
Okay.
So this is my.
Who's appearing?
Lordship, kindly turn to page 1, page 3, Lordship, of his condonation petition.
Yes. Yes.
First page, paragraph 2, he has written, probably it should be 1,
Yes.
that the humble petitioner is filing the civil revision application under section 115 CPC for cancelling and or quashing the order dated 9/12/2024 in Miss Case number 29H of 2024, and Lordship. There is 2 orders. And order dated 12/7/19 in implement / substitution application number 62/115 dated 23/17 passed by the reference court is Khasi Hills district, Khasi Hills, Shillong, Lordship. In the guise of this order of review petition, he is challenging the order of substitution / implement. He has filed an application before the court below regarding mentioning that it is an implement / substitution. That is 2 provision in the CPC, Lordship. Order 1, Rule 10, it is regarding the implement, and substitution will come under Order 22, Rule 3, 4, etc., Lordship. These are 2 separate provisions. That is why, Lordship, that is also in case of reference made between TICMLE as well as Ojendro Kharsandi. The matter was referred before the court below. And after 3-4 years, they file a substitution / implement. It is in their revision petition, page 92. There is nothing to say under what provision he has filed this petition. There is a technical flaws in the case. That is, the learned court rightly rejected the petition of the petitioner petitioner here in Lordship, on 12/7/2019. And that order was 12. Now they have challenged that order in the guise of that review petition. It is not at all maintainable, because from the date of passing of the order dated 12/7/19, it comes after 5 years, 9 months, 19 days for filing the revision petition. Thereafter, Lordship, after 12/7/19, after 210 days, they filed a review petition without there being any condonation petition.
Review petition was filed before the special judicial officer.
Yes, Lordship. Filed before that. That is the crux of the matter.
So review petition was filed against the order dated 12/7.
12/7/19, Lordship.
That review petition was considered by.
That review petition was not considered by
but was taken up.
Yes, Lordship. Taken.
And was rejected.
Due to barred by limitation.
Whatever the case.
Yes, Lordship.
Was rejected or barred. See, we are not going to the merits of the case, but the fact remains that review petition was finally disposed of by this order dated 9/12.
9/12/24.
Yes.
But after disposal, this review petition has not been decided on merit. It decided on barred by limitation. Anyway, there are two parts, Lordship, kindly.
I understand.
Please.
You see, I understand. What you're trying to say, I understand. See, what happens at the trial stage court? See, at the stage of the trial court is under scrutiny now before this court by way of this revision. He has come by way of this revision. So that if the merits is to be looked into as to whether the court below or the special judicial officer is justified in passing the impugn order or not, that is not to be answered now.
Yes.
At this point of time, what he has come basically is filing of the revision petition, and along with it an application for condonation of delay on the grounds that he has stated.
Yes, Lord.
Because of non-receipt of certificate copy and all those things. So we are on that point now.
Yes, Lordship.
So now it is for this court to consider whether he has made out sufficient cause or not for filing of the revision petition. Yes, this revision petition. If at all the court finds that he has no ground, the matter ends there. If the court says yes, he has a ground, he has sufficient cause is made out, then the application will be taken on board. When the matter comes for final consideration, then you can raise this issue as to whether the Red Special Judicial Officer was justified or not in passing the impugn order. I think that should be the natural progress of things. But the court is not to. This court is not to go into what happened.
Yes, Lordship. That is why I am submitting before this honourable court that review petition was dismissed. Then that means the original order attained in finality. That a substitution petition, whatever it may be said, that on 12/7/19, that order attained in finality. He had challenged both the order in revision petition, and in his miscase also, that is a limitation petition, he has also mentioned about both the orders, not only one order passed by the learned court below or on 9/12/24. That is why the revision petition, filing of repetition barred by limitation 5 years, 9 months, 19 days. In first paragraph, he has to mention about both the orders.
$5 years, you said?
9 months, 19 days, Lordship. In my reply, I have stated, Lordship.
Oh, you filed a reply?
I have filed.
Okay.
Paragraph 5, Lordship, I specifically mentioned about that. May I read you?
Yes.
First, I read paragraph 3, Lordship. Paragraph 4, Lordship. Paragraph 4, page 3. And then the opposite party two begs to state that the petitioner, along with one Mestronas Kharsandi, had filed an application being petition number 62/115 dated 23/3/17 for implement / substitution of their names in place of late Ojendra Kharsandi in LA case number 117/2015 before the Special Judicial Officer Nongpo, and the said application was dismissed on 12/7/19 by the learned court below. Against the order dated 12/7/2019, the petitioner, along with St. Mestronas Kharsandi, had filed a review application on 13/2/20, that is after 210 days, without any condonation of delay of filing of the review application, which must be filed within 30 days from the date of passing of the order as per section, that is not section, is the article 124 of the Limitation Act 1963. Section 3 of the Limitation Act provides the bar of limitation, subject to the provision contained in section 4 to 24 inclusive. Every suit instituted, appeal preferred, and application made after prescribed period shall be dismissed, although limitation has not been set up as a defense. It is in the statute itself, Lordship. After statutory period of limitation barred under section 3 of the Limitation Act. There is no condonation petition at the time of filing of the review application. Therefore, the learned court of Special Judicial Officer Shillong, Iskasi Hills, after hearing the parties, dismissed the review application on 9/12/24. That review petition has not been decided on merit. It is totally barred by limitation. That is where the learned court below rightly rejected the petition. Then paragraph 5, Lordship, the opposite party number 2 beg to state that the petitioner's review application was dismissed on the sole ground that the review application was filed after 210 days without any application of condonation of delay. But indeed, in the name of challenging the review order dated 9/12/24, the petitioner prayed for setting aside the quashing of the order dated 12/7/19 in the civil revision petition, which was passed more than 5 years, 9 months, 19 days before the filing of the missed case number 7 of 2025. In view of the above the case, the reason the missed case number 725 is not maintainable in the eye of law. And this application was filed. His uncle died in January, but no certificate of death certificate has been annexed with it when he has died. He must show all the reason sufficient cause for from the filing of review petition. There is some period of 18 days. That is not a matter. But he had challenged the order dated 12/7/19 passed in that application. Therefore, it is totally barred, and under Article 3 of the Lordship, I have also applied the Limitation Act also.
Article or section?
Under section 3. It barred of limitation.
Yes, you have read all.
Subject to the provision contained in the section 4 to 24 inclusive, every suit instituted, appeal prepared, and the application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. If the opposite party also not raised a point, it is the duty of the court to see the limitation period, whether it is filed by barred or not. That is why the learned court below has rightly rejected the petition, review petition filed by the petition. In this regard, I will show some judgment of the Honorable Supreme Court. Without going to the merit of that revision petition, only regarding condemnation petition, Lordship. It is Supreme Court decision. Both the same. But Lordship limitation of 1998 stated same thing.
Yeah.
C.
Yeah.
Had no Lordship. Civil Procedure Code Order Sec Rule 4 and 10 of limitation. Limitation is a mixed question of fact and law. However, there is no hard and fast rule to the every question of limitation is to be treated as a mixed question of law and
See, don't read head notes. Head notes have no consequences.
main. Then second judgment, Lordship, it is paragraph.
Go to the paragraph.
Yes, Lordship. Paragraph 19 of
19.
yes. That is Supreme Court next judgment, Lordship.
Yes.
Merit. The object of the framing in the issue is to determine the material points of the disputes between the parties. For the purpose of the adjudication of issue can be framed in a question of law or fact or a mixed question of the law and fact. The decision in the issue settles the list is in favor of the either of the parties. A distinct issue is to be formed when a material proposition of law or fact is affirmed by the one party and denied by another. Also, there is no necessity to frame an issue because it is the case relates to that second appeal. That is why that is. I am reading the last portion, Lordship. The Limitation Act 1963 in this paragraph, Lordship.
Yes.
The Limitation Act 1963 restricts the right of the litigants by prescribing a time limit within which action must be initiated. Its object is to provide a time or period within which the action has to be initiated. The object of the act is not a destroy or vested right available to law, but to prevent indefinite litigations, and therefore only prescribe a period for initiation of the litigation. The court has described the object of the Limitation Act 1963 in the following decisions. There are so many decisions referred where that it is totally barred up to 20, Lordship, 2021. Then para 20, paragraph para 20 in the side
Yes.
below that, Lordship, the the mandate of section 3 below 20 and another 20.
This is 19. Reference is made to many
20,
judgments.
yes, many judgment. Then paragraph 20.
Where is 20?
Yes, Lordship.
Where is 20?
Second, next page, Lordship.
Next page could be. But
19. The mandate of section 3 of the Limitation Act.
this is not paragraph 20. This is a reference. This is 20 of that case cited.
Yes, Lordship. That is in reference. In that case also, it is stated about the prescribed period of limitation.
Okay.
Then, Lordship, in all other judgment, everything that is regarding prescribed period of limitation. In last page, Lordship,
Last page.
last page of the judgment. I am not reading every page. Therefore, we are of the view that the High Court was not justified in remanding the matter to the court for fresh trial solely with respect to the issue of limitation, and the court below have rightly held that the suit was barred by limitation, and respondent number 1 and 2 are not entitled to any relief. Because it is totally barred, there was no limitation, that is why.
Yes.
And some other cases also, I can show.
If it is the same issue, same point.
Same issues. After that prescribed period of limitation, without condonation petition, they cannot. It is totally barred, and court cannot proceed with the matter. Lordship.
Lord, I'm appealing for the collector in this case, my lord.
Yeah.
Lord,
Yes.
my lord, as far as this case is concerned, my lord, I'll just go in sequence. My lord, at the very beginning, my lord, there was a land acquisition proceeding, my lord, and in that proceeding, my lord, there was dispute as regard to the title of the land. So the collector has referred the matter to the court, and my lord, after the matter was referred, it was the case was registered as reference LA case number 117 of 2015, my lord. Now, my lord, during that reference, one person by the name Sri Ojendra Kharsandi, he was claimant.
2015.
He was the claimant in that particular case, my lord.
What's
During
his
the
name?
pendency,
Ojendra
Kharsandi. He was claimant in that LA proceeding, my lord.
Yes.
Reference proceeding, my lord. And during the pendency of that LA case, my lord, the Ojendra Kharsandi, he expired. Now, the questions has been raised by the petitioner here that the reference was made in the name of a dead person, because Ojendra Kharsandi expired and in his name reference was made. However, as far as the present case is concerned, what we can see from the record, my lord, there was only one application that was given in the year 2008 by the petitioner, where they have not enclosed any death certificate of the Ojendra Kharsandi. They have just simply referred, they have just simply stated that late has died. However, there was no death certificate or whatever, my lord, that has been enclosed along with the their applications. So this the collector, being having the duty for reference, so he has done the reference because there was nothing on record to show that this person has expired. So reference was according
Reference under section 18.
30, my lord.
Or 30.
Yes, my lord.
There was a dispute.
There was a dispute, my lord. So reference was made, And during pendency of that LA proceeding, my lord, the late Ojendra Kharsandi, we do not know, my lord, exactly when did he die, but as we assume that he expired. Now, my lord, after that, my lord,
Mr. Speaker, let me be clear.
My lord.
At least for academic sake,
my lord,
he is said to have expired during the proceedings.
yes,
That means, during the notification of section 4, 6, so on and so forth.
yes.
Till
No, my lord, when the matter was referred to the court, thereafter parties, they have filed their respective claim petitions, my lord, if I am correct. Huh?
First, the notification for land acquisition was issued to Lordship. Thereafter, there is a dispute because I am holding that plot of land, and notice was issued to the my client, respondent number 2 here. Then he came. One person came. He claiming that he is Ojendra Kharsandi. He disputed.
Okay.
Claiming that he is Ojendra Kharsandi. Then he disputed. Then the respondent number 2 filed application before the authority concerned, and thereafter the matter has been referred.
So till the proceeding under section 30 was instituted.
Yes.
That Ojendra was still alive.
We do not know.
We do not know, my lord, that nothing was on record, my lord, because nobody has produced the death certificate. So, in absence of any death certificate, the deputy collector was bound to make the reference to the court because he is not aware whether he actually died or not. Now, what has happened, my lord? One person, the petitioner herein, my lord, he goes before the reference court saying that he is a legal heir of that Ojendra Kharsandi, and he wants to be impleaded in the reference court. Yeah, and thereafter, my lord, 2 persons went before the court, my lord. And however, my lord, that applications which was filed by them, that was rejected by order dated 12/7/2019. And because of ground, my lord, that no provision has been quoted by the applicant, and for technical flaws, my lord, that their applications for impleadment/substitutions was rejected by the court by order dated 12/7/2019. Thereafter, my lord, the petitioner, they have filed a review applications against that order 12/7/2019 of a dismissal order by of a review applications.
Initially order dated
12/7/2019, their applications for substitution/impleadment was rejected, my lord.
Yes.
Against this rejection order, my lord, they have filed a review application.
Yes.
And that was filed on 13/2/2020.
Filed on
13/2/2020.
2020.
This was actually supposed to be filed within 30 days from the date of the order. However, he has filed it beyond the prescribed limitation period, and that too without filing any condonation petition along with the review applications. And therefore, the review applications was rejected by the court. Void order dated 9/12/2024.
Oh, 9/12. Yes.
Now, against this order 9/12/2024 and also against the order dated 12/7/2019, they have preferred these revision applications, my lord. Against both the order. One is 12/7/2019, which is after almost 5 to 6 years, and also they have challenged 9/12/2024. Order passed in review applications. Now, as far as the first order 12/7/2019, that is almost 6 years, my lord, after which they have challenged this order by of this present applications, my lord. Therefore, they have nowhere mentioned anywhere in the applications about the delay in preferring this revision applications, my lord, and they have no explanations for the delay. As far as order dated 9/12/2024 is concerned, my lord, they are saying there is 18 days delay. However, if my lord will see from the date of the order, they have collected the order on 19/12/2024. If we see, they were supposed to file the revision applications within 90 days period. Even then, there is 6 days of delay, even after obtaining the certified copy of the order. So, my lord, in my humble submissions, because they have not explained the delay for almost 6 years of passing the first order, that is 12/7/2019, there is no explanation, and therefore the present applications will not be maintainable where they have challenged both the order. My lord. That is only what I want to say, my lord.
Your Lordship, that's my brother friend and my sister trying to mislead this honorable court. I am hearing this petition.
I'm so sorry, my lord, by this learned senior submissions.
Your Lordship,
I have stated the correct facts, which my learned senior have not
Your Lordship,
stated before this court properly, my lord.
Page 3, when I have stated here, what's the review petition I filed? Then I mentioned this one. It is not that I am going to challenge this order. If this conditional delay petition is considered, then the merit will come, and I can satisfy whether this petition filed, review petition.
Where is your prayer?
Page number 21, my lord. Revision petition, my lord.
Page number 21.
Page number 21 of the revision applications, my lord. They have challenged both the order, my lord.
Yes, Mr.
Yes.
Your Lordship, in this
And even then, my lord, he has
Your
the
Lordship,
audacity of
Your
saying,
Lordship,
I have misled this court, my
Your
lord.
Lordship, in this matter, my conditional delay petition is allowed. Then after that,
See, Mr. Okay, this is your application in the revision petition.
yes. So, Your Lordship, if my conditional delay petition allowed, and then court found that order of the special judicial officer was not correct, then I have to go to the root of the Your Lordship. Then in my petition, I will be decided whether this petition was rejected, and subsequently repeated petition, what was saying this, it was delayed by continuous delay, whether correct or not, then it will go there, Your Lordship, in a main petition. So in my main petition, Your Lordship, if I didn't...
See, Mr. Devnath, even otherwise, if this court, I'm just saying if, I'm not saying it will, accept your contention.
Yes, Your Lordship.
Let's, okay, forget about this condonation petition now. Suppose it is admitted, allowed, your revision is taken on board, matter heard.
Yes, Your Lordship.
You have come against, initially against the order of, where your review application was rejected. That has to be considered.
Yes, Your Lordship.
If, you see, even if the court, suppose now, again we're going, I'm saying if, I'm not saying yes, if the court allows your petition and say that review, the order passed in the review petition is bad, not tenable, whatever, that is set aside.
Yes, Your Lordship.
Now the court at this point of time cannot go into the merits of your application for substitution or implement. That would be incumbent upon the trial court.
Yes, Your Lordship.
So by your prayer to set aside that order, I don't think that's terrible. Not at this stage.
Not
I think you should understand those
Yes, Your
implications.
Lordship. So here, Your Lordship.
What the other side is trying to say, if I understand correctly, is that because of the fact that you have assailed the order passed, you see, in the review, that is why you have no case here.
So
That's what that is. See,
Your Lordship,
that's
here
plain and simple.
in this court, Your Lordship, in this court, they will be taking the decision only this much whether court was right or wrong.
No.
Only this much.
Understood.
So, Your Lordship, this prayer I've given, I've mentioned it, a whole story of it, Your Lordship, and what's the incident thereof, and what would be the consequences. So, Your Lordship, in this respect, the matter for legal points, Your Lordship, the whatsoever merit of the matter.
See, Mr. If I understand correctly, if we go by calculation, taking into account the period of obtaining of a certified copy, his petition is within time. 6 days, you see, here and there, it's just a matter
That
of
is
calculation.
regarding review,
No, regarding the
revision applications.
condonation for revision.
My lord, here, because he has challenged both the order.
Oh, that is, see,
Yes.
that will come, that again I've stated earlier, that issue will come only when the revision petition is taken on board. When that revision petition is taken on board, the parties are heard, then you can raise that issue.
Now, before taking the revision applications by this court, before taking on merit the revision application by this court, the court has to see whether the revision applications filed is within limitation or not, or whether it can be condoned.
Yes, exactly.
Now, while doing so, my lord has to also see, because in this revision application he has challenged the order dated 12/7/2019.
Exactly.
12/7/2019,
Exactly.
after 5 years, 6 years almost.
Exactly. So that is why when the merits of the revision petition is taken into account.
No, prior to that, because they have challenged the order dated 12/7/2019.
He was saying it was not a challenge; it was just a reference.
Exactly, my lord. This is under challenge. It is in his prayer, my lord. Therefore, this present application will not be maintainable
Your Lordship, in this respect,
because he
matter.
has challenged both the order.
I think I can understand the picture.
Yes,
I can
exactly.
understand
That is
the
my
picture.
point.
Maybe
Your Lordship, in this
maybe
respect
he
to
is
the
not,
matter.
you see, maybe the petitioner, see, I'm not saying he, but the petitioner here is not so explicit in his presentation of the application. He should have straight away come for condonation of delay in filing the
Review applications.
No, revision petition.
Revision applications as regard to the order passed in review.
Pass in review. That's all.
If his prayer is only to that extent, we can understand, my lord.
Exactly.
Here, my lord, prayer is also to set aside the order dated 12/7/2019.
I've made it very clear
Yes.
that even otherwise also,
Yes.
this court cannot go into that issue. The court will have no jurisdiction to go into that issue.
Right.
Because the matter has to be either remanded or the order of the review court
My lord.
has to be upheld. That's all.
Right.
Merits will not be taken over.
No, my lord.
So that is the position.
In that
You should
regard,
understand
my
that.
only submission is that because he has challenged both the orders together, and therefore the present application will not be maintainable.
So you amend your petition.
So, Your Lordship, this
You
matter.
amend your condonation petition. It's up to you.
Lordship, after filing of the revision petition, he cannot change anything.
No, I'm not talking about revision. Revision is not in question. This court has not gone to the merits of the revision. It is only on the issue of condonation. If he has,
If the case will remand also, then court has nothing to do anything because it is totally barred by limit.
exactly, see that we are not going to that merits.
Yes, Lord.
We are not going to the merit. This court has got no hand in there.
Only
thing is that
about condonation petition.
only about
Only about condonation.
Now, if, as Mr. Sinkon has said, you have also said the same thing. If, Mr. Devraj, you understand here, if your application for condonation of delay is both for filing of the revision application and reference, with reference to that order passed by the review court, then you have to change your prayer. Otherwise,
This is in this form it is not maintainable.
anyway, that would
Yes.
I will consider.
Yeah.
It's up to you now. I'm giving you that opportunity now to amend your prayer, or I'll reserve this matter for orders.
It is filed under section 115 revision petition. This court cannot convert it into
No, not.
27. No.
I'm not. I'm giving him a chance to withdraw and file a fresh one. That's all.
So, Your Lordship, let me have think about it. Let it come.
You understood this situation? The court is not. You see, the court is not depriving you of your rights. Your right to be heard. It will hear you. But you consider.
Your Lordship, let me have some time because.
You get your instruction. Get your instruction.
Because Mr. Khan was there, Your Lordship, he has prepared this matter. He came to Khan, so Your Lordship, just I am with him, so I have to take instruction from Your Lordship.
Only
2 weeks, Your Lordship. He is
1 week.
sick. 2 weeks, Your Lordship. He's sick.
After hearing this matter, see, for so,
Lordship, the condonation petition may be
just let him get his instruction. After hearing the general counsel for the parties for a substantial period of time, excuse me, Mr. R. Demnat, and the counsel for the petitioner, for the applicant, at this point of time has sought for leave of this court to seek instruction and to apprise this court of the steps to be taken by the petitioner. As prayed for, this is matter to 2 weeks.
From the release, item number 1.
2 weeks. It'll appear no costless. But if you want a date, yes, Mr. Demnat.
Any date convenient of the court.
Wait.
See, date also sometimes some problem come up from either side. You will see. Any date. Any date. I don't even.
Monday. 8 September. 9.
We don't have any of this in LC. We were here and then it's coming, no problem.
Just wasted time of the
sometimes even we feel then also some problem ourselves is coming up. So this any date, so you do not be
fine. So 9 then.
Daily list item number 1.
I'll read out only the operative portion. It is a fact that in course of the proceedings in the said FA number 2 of 2022, the parties therein have brought to the notice of this court about the fact that the copy of the award have not been submitted by the collector before the reference court, which matter is under consideration. Since the said discovery was made only recently, the same not being in the knowledge of the applicant herein, who has contended that it will be affected by such revelation, which goes into the heart of the proceedings before the reference court's decision. Therefore, it is the opinion of this court that such assertion has to be considered in the interest of justice. Irrespective of the numbers of days or years when the related proceedings have proceeded before the respective forums, what is material is the quality of the cause shown. The applicant have been able to convince this court that sufficient cause have been shown to allow condonation of delay of filing the appeal, where an important aspect has to be looked into as far as the said discovery of the non-production of the said copy of the award is concerned. So I've cited some judgment here. In view of the above findings and observation, this court is satisfied that sufficient cause has been shown in preferring this instant application for this court to condone the delay of 1842 days in preferring the said appeal. The application is herein allowed delay of so and so day in filing. The appeal is hereby condoned and the applicant is allowed to file the appeal. registry to register the said appeal and to place the same for admission within 1 week from today. Thank you.
Item number 2.
May please, Your Lordship. Lordship, I've just received a case diary just a while back, Lordship.
What is this case about?
Lordship, this is a case of...
On the previous date, my lord has called for the CD, Lordship.
What is your case, Mr. Sheikh?
This is a case, Lordship, here.
Lordship, this is a case of 302.
302, Lordship. Now, in fact, this is a mob killing, not exactly 302, because in the BNS Act they have added the provision. This is, if it is under 103 subclause 2, Lordship, not A.
Yes. 103.
Subclause, subsection 2, Lordship.
Yes.
So, my lord.
But what?
Lordship, I will have yet to read the thing and I will not be able to assist Your Lordship with, since I've just received. I've just marked some pages.
We'll take it up tomorrow.
Lordship.
Tomorrow?
Lordship, so even the IO has come with the original CD, Lordship, so I can hold it for today and give it to after it's done. Lordship, the IO has come with the original CD.
Yes. This is the original CD.
Yes, Lordship.
You have to return it.
Xerox
I can take a photocopy and...
See, more often than not, I have always insisted that, once the CD is produced, it can be a, photocopy.
Agree, Lordship. Lordship, I think so there was some miscommunication because I've sent a letter,
Because,
I think so.
CD, the court understands that the IO would require it, on
For further investigation.
on a day-to-day basis.
Lordship.
In fact, on an hourly basis, whatever the case may be,
Lordship.
he has to note down. So, what is required is for the court to know the situation or the fact, the latest.
Lordship.
Not immediately, what will happen after the court sitting.
Lordship. Otherwise, if...
So you send, this is a case of which district?
Rajawala, West Garhwal district, Lordship. West Garhwal district.
Otherwise, Lordship, I can hand over the CD. I've marked most of the relevant pages.
You do one thing, Mr. Harwala.
Lordship.
You get it photocopy.
Lordship.
Keep your copy with you. Send back the CD.
Lordship.
Then in that case, Lordship, if then Monday, if not tomorrow, Monday, Lordship.
Where are you going tomorrow? Fishing?
No, Lordship. Yes, because I have one letter before another bench, Lordship. So if
On preliminary with the parties. This is matter Monday.
Monday, Lordship. Maso.
Item number 3.
Lord, here, my lord, I crave my lord's indulgence. My lord, some personal difficulty today. If it is taken up. Item 3 and 4. In fact, my lord, item 3 I had argued on the last occasion. It's part hard, my lord.
Mr. Tapas, you have concluded your submission?
No, my lord. We have to revert to what he has
What had
submitted.
happened,
He has
my lord,
not
on the last
concluded his
occasion,
yet.
my friend had made his submissions. Thereafter, I made my submissions. Now, my lord, in between we had to stop, my lord, because of the...
Lordship had gone for DB.
So, my lord, I have some personal difficulties today. So may I pray, my lord, if this matter is taken up next week or so, my lord.
After a week, my lord.
Joint request?
Let it be joined.
Let it go as joint.
You are in the other case. You have not been heard.
No,
No, my lord.
he has not been heard till now.
Because the first matter which was taken up, my lord, is item 3. My friend had begun his submissions in WPC, what was that?
343.
My lord, WPC 343. He concluded his submissions. Then I was...
438.
Okay. So both matters will be
Yes, yes, my lord.
Yes.
on pre-made by the pre-made by the parties. dismiss matter after 1 week.
Obliged, Your Honor.
Item number 6.
May it please your lordship. As your lordship is aware, this matter is in mediation at the moment. A proposal for settlement has been sent to the state by the private respondent.
The proposal, Your Lordship, it has been put up with the government as of now, so we'll be requiring some more time, Your Lordship, in case there's any possibility for settlement, Your Lordship.
No, you see, at this stage, this court has got no hand in this matter.
Yes.
It is in the hands of the mediator.
Yes.
Precisely.
So the mediator will take necessary steps, call upon the parties, meet them, talk to them, whatever, and then file a report.
Yes,
Please,
That
lordship.
report is not yet here. Perhaps mediator has not.
It's still pending, Your Lordship.
Well, you have not been called by the mediator.
Lordship, we had our last mediation yesterday, I believe.
Session concluded, not concluded.
Lordship, what was discussed there was that the proposal has been sent to government to be considered. So, Lordship,
That would be in the premise of the mediator.
Lordship.
Whoever is the mediator, he or she will take control of the situation, and then even if you say that whatever the case may be, proposal to go to government, this and that, whether response comes from there, it will be for the mediator to take note of that.
Please,
Thereafter, after conferring with the parties, mediator will pass the file the report.
Please, Lordship.
So, at this point of time, what this court can do is just wait
Yes,
the
Your Lordship.
report of the mediator.
Please, Lordship.
May I please, Your Lordship? May I please, Your Lordship?
Oh, yes.
The interim order may continue, Your Lordship.
We have no objection to that, Lordship.
When the matter was called up, both learned counsel of the parties have submitted that the matter is still under consideration in mediation, and as such, since the process of mediation is not yet concluded, this matter may be adjourned for the time being. This court, by order dated 16/7/2025 on consent by the parties, have referred this matter for mediation, and this presume that the mediator has taken charge of the proceedings, as has been admitted to by the parties herein. It would be incumbent upon the mediator to complete the proceedings and to file a report before this court. Since such report has not been filed, perhaps therefore this court would await the final report to be filed. Accordingly, this matter is adjourned for the day and to be listed after 2 weeks, after 3 weeks, or to be taken up as and when the report of the mediator is filed, if the same is done so within the such date fix as agreed to by the as agreed to by the parties, the interim order passed earlier in this case will continue until further orders.
Brief, Lordship.
Much obliged, Lordship.